Welcome to our Wage and Hour webinar. My name is Dave, and I'll be the host for this morning. Well, I'm going to go ahead and turn it over to Artie. Artie is our Wage and Hour Program Supervisor, and I will let him just open it up with a little bit about himself and how long he's been with the department, and turn it over to him. Okay, Artie.
Hey, Dave. Thank you. Appreciate it. Like Dave said, my name is Artie Holmes. I'm the program supervisor for the Wage and Hour Division for the Department of Labor. Been here, matter of fact, I just got my 25-year certificate, so woohoo! And I've been in Wage and Hour 18 years, and the rest was I was in unemployment insurance and employment services. And for about 6 months, I was even in the tax division. So I got a little bit of experience with a lot of different divisions within the department. And while I'm talking or going through the presentation, if you have any questions, just go ahead and shoot them out now when you have them rather than wait for the end. Because sometimes if I try to wait to ask the question, I tend to forget the question I was going to ask and I never end up asking it. So if you have a question, just shoot it out there and we'll get it answered. Now, when we do talk about different types of scenarios and things like that, we won't be speaking to any active claims or anything like that. We'll just be kind of in general for situations. So that being said, let's get started. And the first slide here is the compliance officers. We actually only have 5 compliance officers for the entire state. And so we're kind of broken up in regions. Martina Phillips is located in the Post Falls office. Marina Reynoso, she's in Caldwell. Anita Metro's in Boise. Paul Withers is in Idaho Falls, and I'm in Pocatello. But no matter who you call for a question, they're very good, and they're going to get you the right answers. Now, if they don't know the answer, they're not just going to give you an answer. They'll call and we'll discuss it, and then we'll give you a call back. We want to make sure you're getting all the proper information and not anything just off the cuff type information. And the first thing is what we do is we administer Idaho's wage payment laws, minimum wage law, farm labor contracting licensing laws. And right now we're picking up with the farm labor contracting licensing. And so that we're kind of busy doing that right now. And the minimum wage law, a lot of times we'll get calls of customers asking us, have there been any updates or changes to the minimum wage laws? I hear that minimum wage is going to be going up or whatever it may be. No, there aren't any updates at this time, but the feds did enact something, the Federal Department of Labor. They are changing the thresholds for salary-based employees now. And that should take effect, I believe it's going to be the 1st of next month. But if you want more information on that after the seminar, you can just give me a call and I can shoot that information to you. It'll give you the exact dates and times and the amounts that it's going to be going up to. So I think it's going to be on a tier system. So it's going to go up to 1 point at the 1st of the month, and then a couple months later, it's going to go up again. So if you have any employees that are salary based right now, it's a good thing to have that type of information. And then, of course, Idaho's wage payment laws. So for the wage payment laws, we only have jurisdiction over, wages paid, minimum wage, regular hours worked, not overtime. Overtime is strictly federal. So if we do get a wage claim and it's a mixture between straight time and overtime, well, we can only make a determination on the straight time, not the overtime. If the customer wants to file a claim for the overtime, they're going to have to contact the Federal Department of Labor. We deal with unpaid commissions, bonuses, vacation and PTO, and tip wages. Now for commissions, there's a lot of confusion on that. If you're being paid solely on commissions, and there's a separation, the employer has to pay you just at least minimum wage, which is $7.25 right now, and the commissions are due the way they're normally due. So there's some employers that will have, policies that says something to the effect, you have to be employed at the time the commissions come in order to receive it, things like that. So if you do have something like that in your policy, so give us a call. We will be happy to read through it and let you know whether it's in compliance or not. But commissions it's a big deal of when they are paid. They don't fall within the same time frame like for normal wages, hourly wages. Like after separation, the employee should be paid within 10 business days or the next pay period, whichever is sooner. And again, for commissions, the commissions are due the way they're normally due, but the employee needs to receive at least minimum wage within that 10-day period. Vacation, that's in PTO. If there's any type of sick time, we don't really have any jurisdiction over that because it's not required to be paid upon separation. But vacation and PTO is going to depend on what your company policy says. So if you have a company policy that says upon separation, any accrued and unused PTO will not be paid, then of course it wouldn't need to be paid. But if you don't have that in your policy and the employee has some type of documentation, a pay stub showing the vacation or PTO was given, and you do not have that type of verbiage in your policy, then that PTO is going to be owed. So just have any questions about that, you can always contact any one of us and we'll be happy to answer those questions for you. And then tip wages. Of course, tips are the property of the employee, not the employer. And a lot of times we get questions about that. Well, we received some tips, but the person didn't come back to pick up her tips. Well, both parties are obligated to keep track of the tips. So if you do have tip-based employees, make sure you're keeping track of how much tips they earn during the pay period. And what we typically advise is just mark it down every day. Just keep a running record, and that's the easiest way to do it. I've seen some employers have on just a separate computer, and at the end of each shift, the employee just goes in there and just puts their name, and then just writes how much they received on that particular date. It just makes it easier to keep track of everything. And as far as coverage goes, we go wage payment laws apply when there is an employer-employee relationship exists, which means if there is a independent contractor versus an employee. Well, if it's an independent contractor, we don't have jurisdiction over independent contractors. That person's going to have to go to small claims or civil court to get the issue resolved. And yes, we do have sometimes where a person may file a claim and think that they are an employee, or they think they're an independent contractor and they just may be misclassified. And for our purposes for wage and hour, if there's ever confusion on whether the person was an employee or independent contractor, the first thing we have to do is determine if there was an employer-employee relationship. If it's determined that there was not a relationship, then we dismiss the claim due to lack of jurisdiction. If we determine that there was an employer-employee relationship, then we will proceed on with the claim. We only have jurisdiction over work performed in Idaho. And we see this a lot now. We have other companies like call centers and things like that are in, let's just say, Washington, but the employee is performing work here. And what typically happens is the Washington-based employer is operating off of Washington's wage payment laws. Well, whichever state the work is performed in, that's the labor laws that apply, not where the home company is. So just kind of be aware of that. We can't basically accept claims for anything over $5,000. If a person files a claim that's for more than $5,000, we lose lack of jurisdiction. We kind of match small claims court that way. So if it's over, then we can't proceed. And there are times where an employee may say, well, I'm owed $6,000, but if I can only seek $5,000, perfect, great, I'll go for that. Well, if we know that it's more than $5,000, we have to dismiss it. We can't let the employee acquiesce to a lower amount because it defeats the purpose of the law. So if it's determined that it's more than $5,000, then of course we automatically just lose jurisdiction. And we only have jurisdiction over the employers in the private sector. If it's city, county, state, federal like that, they have to go to the Federal Department of Labor. And I know I'm talking kind of fast here, so if you have any questions or need clarification, just go ahead and shoot those questions out. So the statute of limitations, and this is I'm working one similar to this right now. Well, they have a 1 year. So after separation, if the employer pays the employee some wages that have been paid, it's not all, and it's not the correct amount, they would have 1 year from when the wages were due to file a wage claim. Now, if the employer doesn't pay them anything after separation, then the employee will have 2 years to file a wage claim. So those get kind of difficult, and that's why we stress just keep documentation, keep documentation, keep documentation, because it's going to help you as an employer. Because if we do get a wage claim filed against your company, we'll send you, basically, we send letters, and a lot of times we'll send a letter explaining exactly what we're looking for. And we're only looking for the required documents that the employer is required to keep. If it's requested, we'll request time cards, pay stubs, if there's some type of warnings that are connected to the wage payment, or some type of policy that's connected to the wage payment, yes, we will request that. But we don't really want to get into, we don't get into the separation issue unless the payment of the wages is tied to the separation. So just kind of be aware of that. And again, as always, if you ever have any questions and you have a scenario before you act, give us a call. We'll be happy to walk you through it. And Idaho's a work at will state, so there's no set length of employment. Either party may terminate with or without notice. And that one right there is kind of it's a big one, because we'll get employees who call and say, well, my employer terminated me via text. Well, that's totally okay. At least the employer did give notice, but they didn't like that it was over text or whatever it may have been. Because we get and we understand when the person's terminated, it's a hectic time during their life, and they're dealing with their stress and their emotions and their working situation. So all three of those all at once, they can get kind of overwhelming. And there are times that the employer just doesn't want the employee to come back to the job site for other reasons. So yeah, they can call, send a text, they can do whatever they need just to let them know that they're no longer working there. And if you have some type of contract policy or union agreements, if it's related to the wage payment, that's the only time we'll request those documents. The union agreements, we typically don't get involved in those union agreements unless, again, it's tied to the wages. So Idaho, again, still is a work at will state, and Idaho law does not require vacation, holiday, severance, or sick pay, breaks, lunch breaks, holidays off, pay raises, fringe benefits, and limit to the number of hours an employee can work in any given day, if they're over 16. Now, when we get calls from employers and they don't give breaks, which is totally their decision, but we do try to explain to employers sometimes, if you want your employees to be healthy, happy, and do a safe job and be productive, you kind of want to give them those lunch breaks, and meal period breaks and things like that. As far as the vacation and holiday and severance, that's totally up to the employer. But as far as breaks goes, it really helps your morale in your company. So if you choose to do it, great. If you don't, that's great also. That's totally your decision. And typically we get some questions when we get to this part. So are there any questions about vacations, break periods, lunch periods, or anything like that? Okay.
Real quick, there are a couple of questions and we'll go ahead and, unless you're going to cover these later on, I'll throw them out here to you. When you are issued a 1099-G from the unemployment office, does Social Security and Medicare or CAID get paid in the backside.
And you said a 1099-G?
Correct.
Well, that's more with the independent contractor.
Well, and
And
it looks like I think it's in reference to, since they say from the unemployment office, it must, they're talking about somebody who's received unemployment
oh,
compensation.
okay.
So does Social Security and Medicare or CAID get paid on the backside? So are those wages taxable for Social Security and Medicare?
Okay. For that, you're going to have to contact unfortunately, we don't deal with any of that. So you have to probably contact someone in the unemployment division, one of our, I guess, subject matter experts, excuse me, for the unemployment division. We don't get involved in the tax side, but don't get us wrong. If we do see something that's kind of weird, we will let the employer know, say, hey, you may want to contact your tax person, or you may want to contact our tax department to see kind of what's going on. But we typically don't even jump into that arena.
Okay, thanks. Another question was, where can they find the salary change information? So you had mentioned earlier that there are some changes coming down regarding salary pay. And so
It's going to be on the federal wage and hour division's homepage. If you just Google, federal wage and hour division, it'll come up, and then you can do a search with just salary requirements, and it should bring you up some links and flyers for you.
okay. I'll add that to the chat as well, that link to the federal wage and hour site.
Perfect. And then after the presentation, I'll email you the flyer that we received, and that way you can put it on there as well if you want.
Okay. Another question. We have employees who work in other states for a short period of time on fires. How many days do they have to work in another state before we have to report wages in that other state?
It's going to be, that's another unemployment question, but for that, if any period that you work in another state from 1 day, 1 hour, and you have to report the wages earned in that particular state. So you just have to report it regardless of how much they work, anything, because of course taxes.
Okay. And on that question, I would encourage, if you have questions related to that, our actual tax folks would probably be the better question on that. They're the ones that rule on a lot of times on the independent contractor, and then have more knowledge regarding where wages need to be reported based on the activity of individuals. So are we not required to offer health insurance?
That's federal. So yes, for the federal Department of Labor, you do. So we just acquiesce those guys and take it that route.
Yeah, not a state requirement, but a federal requirement.
Yeah.
If you have it in your policy that you do not pay vacation PTO when terminated, can you choose to pay it out to certain employees that are terminated?
Well, you can, but you're kind of slippery slope. Someone may say, well, Kevin got terminated and they paid it to him. I got terminated, they didn't pay it to me. What's going on? And they may contact the Human Rights Commission or something like that. So if you're going to do it, you probably just want to be consistent with everyone. But again, it's totally your decision on whether you want to pay it or not. Or maybe you can put something in your policy and just say simply, at the employer's discretion. Because we do have seen policies that says upon quit, discharge, or layoff, any accrued and unused PTO or vacation time will not be paid. And you parentheses, whatever you need to do, you can put at the employer's discretion. So that way they may cover it, but still you may get those type of complaints where they contact the Human Rights Commission. Well, they didn't pay it to me because, you know, I was 8 feet tall and they gave it to Kevin because he's only 2 feet tall. I don't know, but those are the type of things you really don't want to, as an employer, kind of be careful with. You want to open yourself up to someone just complaining to complain, so to speak.
How does work at will in Idaho compare to federal laws?
To federal work at will laws? I don't think it does compare. We're kind of a standalone. Each state is going to be a standalone when it comes to wage payment laws, unless it's some type of federal violation. And as far as employment goes, work at will simply just means basically any party can separate without notice. It's work at will. You don't have to give a 2 weeks notice. If you're going to separate, if I'm an employee and I'm getting ready to quit, there's no law that says I have to give a 2 weeks notice. But if you have in your policy, you must give and work until the end of your 2 week notice in order to receive your PTO or something like that, then yeah, you can tie it to that. But ultimately, no, there's no law that says the employee has to give a notice. Now, there are some unemployment insurance laws that talks, like the Warren Act, I want to think that's what they call it, is if there's going to be like a mass layoff or something like that, they'll have to contact the Department of Labor, and then we kind of assist the employer in that large layoff.
Right. Yeah, and that if I'm not sure if that's where the question originated. If so, I mean, at that point, the Warren Notice, which is a federal law, does take jurisdiction. And in most cases, if there's a federal law that addresses something, it would have authority over state laws as far as employment is concerned. Typically, what you're dealing with is states have their own laws that don't necessarily supersede the federal, but are in addition to and sometimes stricter than what the federal law is. So for instance, when you're talking minimum wage, obviously Washington's minimum wage is greater than the federal minimum wage. But when it comes to, for instance, again, the Warren Notice, if you meet the parameters of the federal rules around the Warren Notice, irregardless of whether the state requires it, the federal law requires that. So, is there a minimum requirement for one working day to the next? For example, if an employee doesn't end their shift until midnight, can they turn around and start another shift at 2 a.m.?
Yes. So there's no set minimum or maximum amount of time that an employee can ask an employee to work. Of course, 24 hours is the max because that's all we have in a day. But there's no limit, and as long as they're above 16 years age.
Right. Okay. Can we state in our policy that if you do not give a 2-week notice, your wages for the last pay period would be a minimum wage only?
Yes. And we see those a lot, and they're legal, but you want to make sure they sign that. So some employers will have it in their policy, but forget to have the employee sign the acknowledgement form. And so on those type of claims, that's the first question we ask. Well, did you receive an acknowledgement form indicating you were aware of this basically reduction in pay rate? Because you have to notify them prior to the work being performed to reduce the pay. And if that's in your policy when they're originally onboarded, that meets that requirement. But you have to have that policy signed. We do have some claims where the employer will, say, hey, they knew I sent the email to them. I sent a copy of the back. I know they got it. My supervisor knows that the employee got it, but there's no documentation that they got it. It's not signed, and those are the tough ones. We may think and believe that, yeah, in our heart of hearts, we know the employee got it. But if it's not signed and they deny it, then only thing we can go off is the documentation. And that's why we stress to documentation, documentation, documentation.
Okay, thank you. That's all the questions right now.
Okay. So if there's a independent contractor 1099, these are the tough ones for us because we have a list of maybe 10 to 15 questions where we try to go down and determine whether the person's an employee or an independent contractor. And these are some of the things that we look into. Is it independently established trade, temporary relationship? We've had employees file wage claims and the employer comes back and says, well, hey, they were an independent contractor. Well, how long has this person been an independent contractor? Well, they've been with us now for 5 years. Well, that kind of comes into question. This may not be an independent contractor. And because they were working for them for 5 years, regularly established every 2-week paydays, things like that. So we'll look at it. Can they hire others to do the job? Because if I'm an independent contractor, I can hire someone else to do the job. If the other party says, well, no, you have to do it. Okay, we're starting to get on that borderline of employee. They may take on other work. If they're told no, that you can't, you're solely working for us. Again, that's going to come into questions. The possibility of profit loss. That one's not one of the big ones, but we do ask the question again, just to determine what the relationship is and who's responsible for the tools, materials, equipment. We have some employers who will have their independent contractors wear their shirts, carry their business card. So those are the things we look at. And of course, the W-2 employee, the company directs work, there's an extended period of time, may receive incentives, paid hourly or by salary. If required to work under a licensed individual, uses the company's tools, materials, and equipment. So it's kind of it's just the opposite of what the independent contractor is. And so if there's ever a claim where either party says, well, I'm an independent contractor, but they still wish to file the claim, well, we'll go ahead and process the claim just to see if there's an employer-employee relationship. If it's not, we dismiss. If it is, we move forward. So it's advised if you are going to use independent contractors, get it in writing, something in writing, have a contract. And literally, sometimes we laugh at each other. We say, hey, it's right there. It says contractor. Where's the contract? So that's the first thing we ask for. Did you agree upon that you sign a contract? So, and sometimes we'll get, yes, I did, but it was under duress. And we can't, and we don't get into under duress. We can't establish, we weren't there. And so when a claimant says that, well, I signed the policy under duress, I signed the contract under duress, we really can't get into that. We can only make our determinations off the documentation that we have. So, what I do, is there an opportunity for employers to pay youth less than 20 years of age, less than minimum wage? Yes, you can, but it's only for the first consecutive 90 days. They can be paid at least $4.25 an hour. And we see these a lot of times during the summers. Some of these shaved ice places and things like that. They'll hire those high school kids and have them come work for them, and they're under 20, so they go, okay, we're gonna hire you at $4.25 an hour. And we always suggest give it to them in writing so they can take it home to their parents so they really understand, and it's for the first 90 consecutive days, calendar days. Now, where some employers are getting in trouble, like this summer, someone hired me and I'm 12 to work at the shaved ice stand. and I only actually worked, I don't know, maybe 20 days. And then I come back next year and they want to pay me below minimum wage again. No, once you can only do it once. So as soon as that clock starts, it starts and 90 days goes. So they can do it for the first summer, but the second summer when I come back, they have to pay me at least minimum wage. And we only typically see these claims in the summertime and in the early spring. So the standard minimum wage for Idaho is $7.25 an hour. Tip minimum wage is $3.35 an hour. And that's just standard what we have. And now the problem we do see sometimes is the employer will pay the employee $3.35 an hour. Now, if their tips don't bring them up to at least $7.25, well, then the employer has to make up the difference. And of course, we do have some claims where they paid the $3.35 and the person didn't make enough in tips to raise his pay rate up to minimum wage. So the employer has to, pay the other half. And sometimes both parties, employers and employees, get confused on that. But at the end of the day, $7.25 has to be met. Question. So the employer is paying the tipped employee $3.35 per hour as required by state law. The employer does not have to pay any more as long as that person earns $30 or more in tips per month. Of course, that's false. The employer must ensure that the employee is making at least minimum wage, $7.25 an hour. Tips belong to the employee and are added to the $3.35 per hour. If the base wage with the tips does not add up to at least minimum wage, the employer must make up the difference. Of course, I just kind of covered that. Any questions on that? Because the tip one it's really difficult. And so this Idaho statute basically says the employer has to pay the employee at least once per month. But if that is altered, they have to pay once every 15 days. So typically what a tip-based employee, they'll take their tips home every day. But some employers, they'll go, well, no, we're going to hold it, we're going to keep track, and we'll give you your tips on payday, which is totally legal. If it's you pay once a month, they don't have to keep track the whole month. If you pay every 2 weeks, once every 15 days, then of course, yes, you can save and give it to them on payday. But the tips for the tip-based employee, that's really what they live on, basically. So that's why a lot of employers just give those tips on a daily basis. But again, keep track of it if you do give it on a daily basis.
There was a question in here. When is minimum wage changing?
For Idaho, it's not. Well, I can't say it's not. I don't know when it's going to change. There just haven't been anyone in Idaho addressing that issue to raise the minimum wage. I remember maybe 15 years ago, I want to say, there was a smaller city that determined that their minimum wage for their city was going to be $12 an hour, which is totally fine because it was above the 725. We didn't require it, but that's what their pay rate that they were paying. But as far as it going up, I haven't received any information saying that it's going to be going up anytime soon. But if it does, you can bet we'll get all the information out. We'll have newspaper, internet, everything, every type of medium that there is, we'll get that information out just so the public knows, because the public does need to know about this because it's very important. But no, it's not going up.
Another question, not necessarily related to minimum wage, but back on the independent contractor situation. Can we have the same employee be a W-2 and a 1099 employee? The example is a company has outside salesmen that they pay a salary to. Then in the fall, a vendor sends money to pay the salesman a bonus on products they sold for them. do they have to include that bonus on the W-2, or can they cut a check and give them a 1099 at the end of the year for that commission, that bonus?
That's a tough one. That's probably going to be more for our tax department, but typically it's not advisable to operate like that, because then the two types of employment and the wages, they start to mix together and gets convoluted. If you have something specifically written out when you're doing these activities, you're not an employee, you're independent contractor, you have everything all signed, you can, but it just gets messy. And when it comes to taxes and things like that, you don't want it messy. And I'm trying to answer the question, but I would probably call our tax department, because that's more in their realm. But I have seen it done before. And those type of claims, wow, they get interesting, because dates overlap, work overlap, payments overlap, and it just, I don't know, it's just messy.
And I would say, I think the key there is, if the work that they are performing for this vendor, or that's resulting in this additional bonus commission from this vendor, is work that they performed while they were in employment. So if it's during the same hours, just in the normal course of their job, but this vendor is providing them an additional bonus or commission based on that, I am going to guess that that would still be a part of their wage, because there would be no way to separate the work that they're performing as an employee from the work that's being performed for someone else, because it's the same hours. So,
but yeah, those are tough ones.
Yeah. So,
great question.
That's it for right now.
Okay. So when we talk about hours worked, of course, is for the non-exempt employees should be paid the agreed upon hourly pay rate. Now, here's the thing: if you hire someone and they ask you what's the pay rate and can I get it in writing, statutorily you have to give it to them in writing. If they don't ask for it, then of course you don't have to give it to them in writing. But it's suggested that you give it to them in writing just up front, just because it just takes all the gray areas away. And sometimes I may say $15 an hour, but the employee heard $18 an hour. Well, no, I said 15. No, you said 18. Okay, it's already right here in writing. I said 15. So it's really, really nice just to be upfront. Just give the paper to them and let them know exactly what they're making. But they have to be paid at least minimum wage for each hour worked, which of course is $7.25. And overtime is for any hours worked after 40 hours in 1 week, or a 7-day work week, 7-day period, used typically Sunday through Saturday. Now, we have had claims where the employer is using a 2-week pay period in 80 hours, which is incorrect. It's based on 1 week, any 7-day period. And it's anything worked past 40 in 1 week. Now, you may have a person that, I don't know, worked 40 hours and then all the way up to Thursday, and then there was vacation, in which gave them an additional 8 hours because it was a vacation, and the employee wants to be paid that 8 hours in overtime. Well, that's not the case. It's for actual physical work performed. If it was vacation, PTO, or something like that, there was no physical work, then the overtime isn't owed. It's only for hours worked, physically worked, in over 40 hours. And you can't round and use 2 weeks and things like that. Each week stands alone. And now when we say work, we use this definition: suffer or permitted, they must be paid. Now, we do have claims where the employer had no idea that the employee was working. There's no work product presented or anything like that. And we get those claims. And first thing we ask is, well, did you work? And the employee says, yes, I did. And the employer comes back and says, well, no, we had no idea. There's no work product. There's nothing there. So you wouldn't be obligated to pay them anything. They can file the claim because that's still within their rights. And we'll contact you, get your documentation. And if they weren't suffer permitted to work, there's no work there. But on the flip side, same type of deal. An employer will let an employee work before they have all the paperwork filled out, before they turn in their driver's license, the I-9, and all that stuff. And then that person works for a day and a half and then quits. Well, they would be owed the wages for that period. And these are tricky ones because the employer let the employee work without having the proper paperwork completed. There was no talk about the pay rate or anything like that. Well, if there's no documentation of the actual pay rate, the burden of proof is going to be on the claimant, the employee. If there's no proof of anything, we would have to award it at $7.25 minimum wage because that's what has to be paid. So we suggest that you don't let people work until you have all the proper paperwork. Even as far as background checks, we do have people hire employees and then say, okay, you're going to start working today pending the return of your background check. Okay, fine. But all that work that they perform, it has got to be paid for. So just kind of be careful with those type of things because we have gotten those responses. Well, it was, we were just trying them out. It was more of a work test. No, we don't have work tests. So what was that industry? I want to say dentists. They used to have dental assistants come in and do work tests. Well, a customer came in and see if the person had the skills, they would say, okay, go ahead, give this person a cleaning, see what's going on. And then if you do well, we'll pay you. Well, that's compensable time. That person has to be paid for that time. And so if you are going to do something like that, call it a trial period and just say, hey, during this trial period, your pay rate is going to be minimum wage. Once you pass the trial period, we will bump your pay rate up. So that way, if that person comes in, see the person's doing that work, you don't think it's going to be a good fit, they only work for 2 hours, you only pay them for $7.25 for 2 hours of work, and then you kind of just move on. But again, document everything documented just because it just protects yourself. Okay, hours worked. Now, if you do offer a rest period break and meal period breaks to your employees, the rest period break is usually 20 minutes or less. And it may be called, you may be called back to work, is counted as hours worked. So just kind of be aware of that. Now with the lunch times, it has to be 30 minutes or more, and the person has to be completely relieved from work or duty. Then it wouldn't be counted as work hours. Now here's the issue we see sometimes is I'm working for my employer and they say, okay, it's your lunch break, but take the phone with you. And so if you get any phone calls, you can assist, you can help out. Well, I'm not totally or completely relieved from duty or relieved from work because I took the phone with me. Now, if I take the phone with me and I don't get any phone calls, am I completely relieved from duty? Some say yes, some say no, and that's why we have to look into it in more detail. So those are the tough ones. But typically, just carrying the phone by itself doesn't necessarily mean it's going to be compensable. Did you receive any phone calls? Did you sending text messages? Even if it's one, that's you're not relieved from duty. So just kind of be aware of those type of things. Okay, and these are the fun ones. Wait time, and so if it's compensable, they're unable to use time for their own purpose. Use of time is controlled by the employer. If it falls within that, then it's going to be compensable, meaning it's going to be payable time. Not compensable, the employee is able to use the time for their own purposes and they're completely relieved from work. So those are the two things we really look at when we get into compensable and non-compensable time. We've had a claim filed before where the person had to go through a decontamination, I guess, unit or system before they actually started working. Well, that's not compensable time. The time it takes, preparing for work is not going to be compensable. But once they get to the other side of the decontamination unit, then it starts. So if you have those type of situations, give us a call. We will be happy to walk you through those. And this is considered hours worked for on-call time. So if it's compensable, it requires to stay on the employer's premises. Now, there are times due to security reasons that they call it a campus, you're not going to be allowed to leave the campus. If it's for legitimate security reasons, then we would still say it's not compensable. But again, that's why we would have to ask more questions. If they're required to be so close that time cannot be used effectively for their own purpose, I'm off work. My employer tells me I'm a big hunter. Says, okay, you can't leave the area. You can't go down to Utah and go hunting because we may need you to come to work. Well, I'm not totally relieved from duty. I mean, I can't use my own time effectively. Not compensable. They're required to provide contact information. Yeah, just give me your contact information. If we need you, we'll give you a call. And they're able to use the time for their own purposes. Not, okay, you can take the day off, but take the phone with you. When I call, you better be able to get back within 25 minutes, those type of things. That's typically going to come back as compensable time. Hours worked, training time, compensable, not compensable. Meetings, lectures, or trainings for the employer's benefit is going to be compensable time. Any type of meeting, lectures, or training that's required for the employee to attend is going to be compensable time. So all 4 criteria have to be met for it not to be compensable. Outside the regular hours work, voluntary, not job related, and no employer work is performed. So that's the only way it would not be compensable if all 4 criteria are met. And the main one we see a lot is voluntary. The other 3 may be there, but then there's something in their policy that says, it's your choice if you want to, it's not voluntary. But then we ask the follow-up question. So if it's voluntary, if I don't attend, am I going to be written up? Am I going to receive a negative, referral or whatever, there's some type of negative consequence, then it may revert back over to compensable time. So just kind of be aware and reread your policies. And if you have any questions, you can always send them to us and we'll be happy to review it and help you. We won't rewrite it for you, but we'll point out things that just to kind of help you come into compliance. So it just makes life easier for you, me, and the employee. So hours worked, travel time. So compensable between job sites during a normal workday is going to be compensable. Not compensable, ordinary home to work travel is not going to be compensable. And that travel away from home has special rules. So I typically work in Pocatello, and tomorrow my employer wants me to work in Idaho Falls. So if he wants me to work in Idaho Falls, that becomes my new job site. So the employer doesn't have to pay for me to drive from here to Idaho Falls to start work. Now, if I report to the Pocatello office, pick up tools, take the company vehicle, and I drive to Idaho Falls, well, that clock started when I was in Pocatello loading the vehicle, getting ready, and then leaving. So now I'm on the clock. But if they say you need to be in Idaho Falls tomorrow morning at 8 o'clock, that's going to be considered home to work. And so if it's home to work, because that's my new job site, it's not going to be compensable. If I have to stop off in Pocatello first, pick up anything, do anything, get in the company vehicle, I'm on the clock. And if you have questions about those, you can always just give us a call. So an hourly employee is traveling to your paid training in Portland. They leave at 7 p.m. Thursday and return Saturday at 2 p.m. Does the employee have to be paid for Saturday's hours? So there's the answer. The DOL doesn't include travel away from home outside regular hours as a passenger on an airplane, train, boat, or bus, or car as work time. But you must count hours worked on regular working days and work hours on non-working days. So it gets convoluted and it gets confusing sometimes. So if you have those unique type of situations like this, send it to us. We'll be happy to read it. And whenever we get these type of questions, what we end up doing is we'll all read it, and so that way we're all on the same page, and then we'll get back to the employer to answer their question. And we say that because we always want the employer to get the same answer, no matter which compliance officer they speak with. We always want to be on the same page.
Artie, we have a couple of questions
Okay.
along that line or similar type of area. First one, please touch on expectations for exempt employees. Should exempt employees be required to clock in and out? If clocking in and out, should the company be paying overtime?
Okay. If they're salary exempt, no, you won't have to pay the overtime if they're clocking in and clocking out. But we do tell people to at least keep track of the time. And the exempt employee will not like it. They won't like it because they're salary exempt. It doesn't matter. But if there's ever a time where there's some type of dispute, the first question they're going to ask is, did you keep track of your days and hours of work? And they're going to come back and go, well, no, because I was salary. I didn't keep track of time. So how much are you owed? Well, I don't know because I never kept track of time. And then we'll go to the employer, say the same thing. Well, did you keep track of time? And then you'll say no, and that would be the end of it. But if it's a overtime claim and it's going to be federal, they're going to ask for the hours of work as well. And they'll make their determination based off, they go a bit more in depth than we do when it comes to this type of issue. So we always say, yes, keep track of time. Even though your employees are salary exempt, meaning exempt from overtime, it still doesn't hurt to keep track of time. And because what's going to happen is if there ever is a separation, so what happens if you're salary and salary exempt, that first week of employment, if you do not work the full of that week, you can prorate it to an hourly basis. And the same thing goes for the final week of employment. If that salary-based employee does not work that full week, well, then on that last week, then you can prorate it down to their hourly basis. So that's why I say, yes, still keep track of time, because and sometimes you just never know when a separation is going to occur, but you always know when they first come in, here you go. And you may get that question from the employee, well, this isn't my salary. When they receive their first check, well, this isn't my salary. Well, you do know the first week you only worked 15 hours because you came in, and started your job on Thursday and Friday. So we prorated that. The following week, it was your whole entire salary. So yes, it is a good idea to keep track of time. It always is. But if you don't, there's no statute for the salary-based employee that says you have to, except for the statutes do say that both parties are obligated to keep track of time. And just by saying someone is on salary and salary exempt doesn't mean that you don't have to keep track of time. I hope that answers your question.
Okay, so another one, if a commission-only employee is hired and leaves within 8 days and did not earn any commissions or clock in any hours, are we still obligated to pay him minimum wage for the 8 days?
Yes. Because if they're solely commissioned, their pay rate is minimum wage or commissions, whichever is higher. So if they don't bring any commissions, you just pay them for their hourly work.
Are you required to pay for the time the employee comes in to fill out new hire paperwork?
No,
Okay.
but because that's going to be pre-employment. So they're filling out the paperwork. Nope. Now, we have had people come in and say, okay, it's today. What is today? Wednesday. Um, I'll come in today and I fill out the pre-hire paperwork. And then once you get the paperwork, you put me to work. Once you go through it and you make sure I submitted everything correctly, then you put me to work. And we do have those where they come in and as soon as they get there, the employer says, okay, you're hired. Then if they're doing that paperwork after they're hired, well, then yes, and just make it very clear to the employee, you're not hired yet. This is the pre-employment paperwork. Once you get your paperwork completed and we get it confirmed, then you're going to be hired.
Okay. If an employee is only scheduled for 40, but consistently clocks out late, am I obligated to pay the overtime at time and a half?
So they work 40 hours a week and they're clocking out late. It all depends on that time. What are they doing during that time? Why are they late? One. Um, so if I'm supposed to get off at, that person is supposed to get off at 5 o'clock, why are they waiting till 6 o'clock to clock out? Are they just hanging out? What's kind of going on? Is any work being done? If there's work that's being done, I would pay them and then sit down and talk to them and let them know that, hey, in order for you to get overtime, it has to be approved through management first. You just can't arbitrarily um, work over and expect to be paid. It has to be approved. If you do not get it approved and you continue to do this, it may lead to disciplinary actions up to and including termination because you're not following company policy. Just make it very clear that it has to be approved. Now, if a person works that overtime and it wasn't approved, but there is some type of work product, yeah, unfortunately, you still have to pay them. But then now you just take, your disciplinary actions. So, and you really can't use wages as a form of punishment. But if you outline it for them, this isn't punishment, and we're not punishing your wages. What we're doing is trying to get you to follow the company policy that we both want to follow.
Do you have to pay the prospective employee for a work interview?
Yes. If any type of work is being performed during the interview, um, they have to be paid for it. Now, what you can do, you can pay it at a lower pay rate. You can just let them know from the beginning, okay, this is going to be a working interview. Your pay rate is going to be minimum wage, $7.25. Person says yes, they do it, and that way you'll find out whether the person can do the job or whatever it may be. Then, yeah, you pay them at $7.25.
Okay. Next one, employees are given a 30-minute lunch, but they don't take the full 30 minutes given. Do they need to be paid as if not taking a lunch?
Only if there's some type of work product being done. But again, in that scenario, and I'm not trying to be harsh or anything, write them up, let them know, and don't, even if it's a verbal warning, still document verbal warnings. Just write on the paper, verbal, but let them know that our lunch times go from 12 to 12:30. You're expected to take your break then, because if they don't and they start working, sooner or later, someone's going to get disgruntled and they're going to say, well, hey, I've been putting in all this time, you're not paying me for it, just a bunch of stuff. So just just be consistent with it. And if the person is not taking lunches, have a conversation with them. It shouldn't be a difficult conversation because these are our lunch times. We are expected to follow company policy. You sign the acknowledgement form indicating that you would follow company policies. You are not. So that way now, if there's some type of separation, that person files for unemployment insurance, and you have the documentation showing that they were warned They're aware of the consequences of their actions. They were given an opportunity to change, and they didn't. So you protect your unemployment insurance account that way also. It's the documentation.
My employees drive company cars all day and go from job to job. I pay them drive time between jobs, but they are allowed to stop for a break as long as it's along the route and they clock out. They usually stop at a gas station, clock out, eat their lunches, use the restroom, etc., and then clock back in when they restart the route. What problems might this present for me?
So they're taking, so say they're driving, they just have to use the bathroom. They shouldn't have to clock out for that. But for the lunchtime, yes.
Yeah. And as far as, what problems might it present? There shouldn't be any problems because they're not actually performing any work.
Correct.
It's on their lunch break. So
there shouldn't be any problem. And the only thing I can possibly see is someone saying, well, because of this, I work 42 hours a week, so I have some overtime. That's the only possible thing I can see. But other than that, no, I think you're doing it. That's probably the way I would do it.
if you have an employee on call all weekend and are required to answer a phone every time it rings, should they be paid hourly?
Unless they're salary, yes. And again, you can change the on-call time to minimum wage. Just put it in writing. Any on-call time will be paid at minimum wage. Once you pick up that phone and start making calls, you go back to your normal pay rate.
Okay. Training time, comp time, if it is not their normal work time and is a mandatory meeting, are we required to pay their travel time to the meeting or mileage?
Well, yes. But the thing is, comp time for the private sector, you can use what they call flex time, but comp time is basically, stacking of hours. So basically, if I work, I don't know, an extra 2 hours on Friday this week, I can just save it and go over to the next week. No, we can't do that. But flex time is, hey, I work Monday, I work 2 extra hours. So Friday, I get to go home 2 hours earlier. You can do that. But as far as comp time, you need to be paid for those hours for that particular week. Now, what was the other part of the question? Sorry.
So are they required to pay their travel time to a meeting or pay mileage if it's a mandatory meeting and it's not during their normal work time?
Yes, the whole thing is going to be mandatory. Now, but what you can say is instead of having them, come in and pick up the car, just have them just go straight there. And then it would only start when they got there.
Okay. If a salaried employee works less than 40 hours, can they be paid less?
No, there's only certain times you can make deductions from a salary-based employee, and of course that's federal. And we have a fact sheet that tells you exactly when you can and cannot make deductions from a salary-based employee. And that's a really, really good fact sheet to have. There's two of them. There's 17A and 17G. So if you ever do get to the federal webpage, federal wage and hour, just type in fact sheet 17A and 17G. I believe that's what they are.
Okay.
And
if a salary, go ahead.
And it'll just break everything down for you.
If a salary employee is not working the required written set amount of hours, how do you handle that, especially if it becomes a reoccurring problem?
You still have to pay them because unless it's one of those reasons that you can make deductions from their wages, and if you're having those type of difficulties, pay them, and on payday, let them know that they're going to go back to hourly. because salary. And I hate to say it this way, but if you have employees that are on salary, it's a trust thing. It really is. Some people will take advantage of it because they know you can't make deductions from their wages. So I'll just come in on Monday, put a couple hours in, I'm done. Go ahead and pay me. But then not everyone. So just kind of be careful with it. If someone is abusing or is not meeting the agreement, you're always within your rights to go ahead and just change them to hourly and just pay them for the time that they're there. They're probably not going to like it, but you're being compensated for the hours of work. So,
does the exempt federal law say that you can work so many hours that it looks like you make less than minimum wage?
don't know if I understand that one, but one more time. Does it?
Does the exempt federal law, so the portion of the federal law, so I'm assuming like a salaried employee that's
Right.
exempt, say that you can work as many hours or work so many hours that it looks like you make less than minimum wage?
Oh, yeah. The hard part, that's the double-edged sword of salary. You have to pay them the same whether that person works 20 hours in that week or if they work 65 hours in that week, they still need to be paid the same. So it could look as if they didn't make at least minimum wage, but as long as the salary thresholds are being met, that's what we would go off of.
Okay. Are you required to pay overtime for commission employees if hours are more than commission?
Are they solely commission or they have a base pay rate plus commission?
The way the question's worded, I would say they're solely commission.
Okay. Solely commission. If it's totally outside sales, no. If it's a mixture, then yes.
Okay. So I've heard that, and this is a follow-up to an earlier question, I've heard that exempt employees can come back on the company and request back pay if overtime or for overtime if they are clocking in and out.
I haven't heard that, but it's going to be federal. So, and that's probably why we don't ever get that type of question, because if it's overtime, we won't have any jurisdiction. So we just refer them straight to the feds. But I can understand what you're saying is okay. So you're keeping track of time, and now there's documentation showing that this person wasn't technically supposed to be classified as a salary exempt employee. They should have been paid hourly. Well, then now you have the hours, and now you know exactly what they should have been paid, or they could have been overpaid. So that's why it's good to keep track of time. But if you have a salary-based employee and you're fearful of that, then just continue. I wouldn't keep track of time, but ultimately, that you're going to get asked that question: do you have the record of hours worked? And I guarantee you, if you don't have those hours, that employee does.
If employees take pre-employment test, do you have to pay for that?
Pre-employment test, like a typing test, something like that. I'm thinking. No, as long as whatever they're testing is not being used for a customer, and you're not receiving any type of payment through a debit or credit card or cash for the test. So if you take a typing test, pre-employment to get employed, no. If I sit down at the dental office and I'm a dental assistant and they're testing me on my skills, then yes, because it's going to be helping your customer, and that customer is going to be paying in some manner.
So for salaried exempt employees, if they are working less than their scheduled hours, are we allowed to pay them accordingly, or do we have to maintain their full salary? And I think you've already answered that.
Yeah.
They would have to be paid the salary.
Unless it's one of the reasons where you can make deductions from their wages.
Right.
So I would get fact sheet 17A and 17G and just go through it.
Can you be a little more specific on the clocking out late? If we have a rounding rule of 7 minutes and the employee consistently clocks out after 8 minutes to get the extra quarter hour and it runs to overtime, do we have to pay it at the overtime rate?
Oh, I would say no in that scenario because we would probably look at it as de minimis. You know, you can clock in, you just can always round to meet the employee's favor. So I would use de minimis on that. If it's 1 minute, then it kind of adds up over a period of time. Yes, I would say yes, but sit down with that employee and just let them know, hey, it shouldn't take you 8 minutes to clock out. It's literally a minute, minute and a half.
Okay. Under 16, what days can they work past 7 p.m.?
Ooh, it's a time of year. I want to say June through July. I want to say they can work until 9 p.m. But that's about it.
There is, and to help with that question and for everyone else on the call, there are on the Federal Department of Labor website, there is a whole section on child labor laws,
Yeah.
and they actually have a really nice pamphlet that outlines the specifics
Right.
along with what type of work individuals can do that are underage. And I would just highly encourage you to get that and take a look at it. The prospective employee sends a resume and we ask them to come to an interview to determine if they are a possible candidate. Are you saying that we have to pay them for the interview time?
No, it's just
No.
an interview. They aren't hired yet. No, not saying that.
No, I think what Victor on this question, if the interview is involving the person performing actual work on, again, going back to the dental assistant, if you're bringing that person in to perform actual work on a client that's paying you for services, then that is actual work that that person is performing. And if that were a portion of the interview, then yes, that person would have to be paid for that activity. But if you're just performing a normal interview, they're coming in, being asked questions, taking an assessment associated with the interview, you have a CPR dummy and they're performing CPR on the dummy to show that they can perform the appropriate type of work. That's just a part of the interview,
Right.
determining their skills. Be no different than administering a typing test or something to the individual.
Correct.
We have an employee who read the employee handbook, verbally told the president that he read and agreed to the policy, but refuses to sign the acknowledgement page. We indicate that he never signs anything. Can we document this and file in his employee file?
Yes, you can, but just make sure that it's not one-on-one and have them at least have that person at least write down, I refuse to sign it, something to that effect. And then if this person is being onboarded and you're bringing them on, well, that's kind of a red flag from the beginning. So just kind of be careful.
If the employee is on call for the weekend and we required to pay them, or excuse me, are we required to pay them even if they don't receive a phone call?
Yes, and that's going to get into how much direction and control you still have over them. It really gets back into Um, what can they do? Can they go about their normal activities as if they were off, or are they required to stay within a certain proximity? If they're required to stay within a certain proximity, well, then they aren't able to do what they would normally want to do, like go hunting and fishing or something like that. That's going to be outside of the 25 miles. Um, those are tough ones. Are they carrying a company phone, or are they carrying their own personal phone? Um, if I don't answer, am I going to be written up, or is someone else just going to be called? So those are the type of things we'll have to look into. So that's a kind of a hard question for us.
I know we're not required to allow employees to take a break. I have an employee who keeps taking smoke breaks multiple times during the day. Am I okay if I say that's fine, but that they must clock out?
Multiple. You're gonna have to sit down with that person and go over your policy and just let them know, hey, smoke breaks are from this time to this time, or breaks are from this time to this time. This is when you can have your smoke break. These mini breaks throughout the day that you keep taking is not acceptable. Write them up and just get a hold of it right now. Because if they're spending if I take 4 smoke breaks during the day, that's going to be at least half hour. And I know, some smokers will say, I'm only out there for 2 minutes, but technically it's going to all add up. So start writing that person up, start documenting it. So, because there's probably going to be a separation, so you can protect yourself for unemployment insurance. But sit them down, stick to your policies. You have to stick to your policies, because if you don't stick to your policy, then at some point it's going to be condoned behavior. And so just stick to your policies. Smoke breaks our break times are from this time. This is when you can smoke. And I get it. I Heck, I used to chew tobacco, so I totally get it. So
Um, we still have a number of questions, but just based on our time, how many more slides do you have or how
I
much more
have
information do you have to cover?
About 16 more slides.
Okay, why don't you go ahead and go through that? We will address the questions after you're fully done,
Okay.
the ones that are left. Okay.
And I'll speed through these. Overtime versus comp time. So of course, overtime is anything worked over 40 hours in that 7 days during that particular week. Comp time is only made available, to government agencies. So, but there is flex time, where you work 10 hours. You work 8 hours a day. You can work 10 on Monday, and then 6 on Tuesday. So, but you can do that, but you can't use the comp time. Exempt versus non-exempt, and I think we may have covered this one already. Yeah, we have. So we've been talking about these, exempt from overtime and non-exempt and eligible for overtime. And this is going to be going up. And like I said, I do have the flyer that they sent out, and I'm sure there's going to be my emails probably listed someplace on it, and we can forward that to you. So payment of wages, like I said earlier, the statute basically says you have to pay them once a month, but if you alter it, it has to be paid at least once every 15 days. And we do see the ones with the pay cards and direct deposit. It's not required. You can't make it mandatory. It has to be voluntary. And at any time the employee decides that they don't want to be on direct deposit, then of course you do have to issue that live check. Non-workday payday must be paid on the preceding workday. So just kind of be aware with that. Now with the payments of cash, we don't suggest that you pay in cash, but if you do, write something up on a sticky note, get something, have them initial it, something, because cash is kind of hard to track, as you guys know. And if you pay someone in cash, and there's no documentation of it, that person could technically file a claim and go, hey, where's the I wasn't paid. They never paid me. And they will ask you for time cards, pay stubs, and you'll say, well, no, we paid in cash. Um, I'm not saying that you didn't pay them in cash, but where's the documentation? Because there's statutes that say you're supposed to, for every pay period, you're supposed to get the employee documentation of any deductions made from their wages. So where's that pay stub? And we're not going to say you didn't pay them. We're just going to say, hey, there's no documentation showing that you paid them. So in Idaho, upon termination, how long does an employer have to pay the employee's wages? Well, I think we covered that a little bit too. It's the 10-day rule, 10 business days, or the next pay period, whichever sooner, unless that person gives a written notice, then it has to be made available within 48 hours at the usual place. Now, with the 48-hour, we do have cases where the person will send the employer a text message requesting their final wages within 48 hours. Well, if the employer responds to the text message, whatever time they responded, that's when the clock starts. So if that employee sends it on Friday and the employer doesn't respond back until Monday, well, that's when the clock starts. We have to have confirmation. Same thing with an email. We all know that the person probably got it, but when did they respond to it? So we suggest that they give it in person, just document who they gave it to, a date and time, and kind of go from there. But again, if you get a request for final wages via text, and it's just going to give you a live one, well, the employer came back and said pound sand. Well, for our purposes, they received it. And so we ended up applying penalties for not being paid on time on that one. Upon termination by either party. And sometimes we will have an employer would say, well, they quit, so I don't have to pay them. Well, no, it doesn't make a difference whether quit, discharge, layoff. Either party can do it. And it's the 10 business days. Written request, 48 hours. Penalties for final wages. So for penalties, we can only assess penalties on final wages for the final pay period. And we have to establish that the wages were withheld willfully, arbitrarily, and without cause. Those three have to be met. And so that's why we always ask, if we contact you, just respond, because it's not automatic. Some employees think it's automatic, and we explain it to them. There's a potential for it, but this criteria has to be met. Did you contribute to it? Did you not show up? I mean, some things we'll have to go in more detail, kind of what happened. And the maximum penalty amount is going to be $750. Now, with that, so if the claim is worth $1,500, the maximum amount we can penalize is going to be $750. Now, it doesn't happen very often, but we can. But typically, our processes are, if the claim is worth $300, we're not going to penalize the employer $750. Now, when I say not, it just goes to basically it's not guaranteed, but our as of this time, for the past, 19 years, it's been this way. We will not ever award $750 to a $300 claim unless there's special circumstances. And so in my time, there's only been about 3 that were awarded $750 off a claim that's maybe $100, $200, something like that. And when we did it, the employer came back and said, well, it's because we had all these other claims and you guys just taking it out on us. Well, no, because each claim stands alone. We don't do class actions or anything like that. It was just egregious. So that's where we are with that. Withholding of wages. Now this is the good one. So advances. So if you give an employee an advance, document it, because you can deduct those dollar for dollar without written authorization. Okay, advances. Overpayments may be deducted dollar for dollar without written authorization, meaning we have to have the documentation to see it though. Loans, written signed agreements to deduct from wages. Agreed upon amount payment must meet minimum wage. So basically, if you give an employee a loan, you just can arbitrarily take it from his wages. So if you have something from the employee that says, I give permission for you to deduct X amount of dollars, from my pay period to pay back the loan, fine, you can do that. But you can't reduce the pay below minimum wage. So you pay them at minimum wage and keep everything, keep the rest. So you have to have that written permission to touch the employee's wages for anything, uniforms, keys, vehicles, anything, company equipment. If you break my equipment, it's going to be the amount's going to be deducted from your wages. Fine, you can do that, but you can't make it go below minimum wage. And if that person files for unemployment, files a wage claim, we are going to ask, where'd you come up with this amount? How much did it cost to get fixed? Where are the receipts, basically? So it's just not arbitrary. So, but be careful with those. And if you have any questions on the advances, overpayments, or loans, give any one of us a call. We'll be happy to kind of help you walk through things. And if you send us your policy, we'll read it. We're not going to write your policy, but we'll tell you what's needed to be in compliance. And withholding of wages, you cannot withhold or divert any portion of a person's wages unless you're required to by state and federal law, written authorization from the employee for a lawful purpose. Example, uniforms, shortages, training costs, damage to company equipment. You have to have that written permission to make those deductions prior to the incident occurring. So just kind of be aware of that. We've had some claims in the past where the employee says, well, they made these deductions from our wages and I didn't sign anything giving them permission to do so. And then when we get the documentation from the employer, there it is, they signed for it. Well, that's the end of the claim. But if we contact the employer, they don't have the written permission, then of course we would award the wages back to the employee. Now this is the one where it comes in where the employee will say, well, they made me sign it under duress. And so we go, okay, so when did the deduction take place? Okay, when did you sign the form giving permission to make deductions from your wages? It was after the deductions were made. Well, it has to be before. So get the signature, get it signed, get it dated. Withholding wages, minimum wage compliance exercise. So hourly rate, $8 an hour, hours worked, 30. So that's $240. Uniform cost, 30. Leaves worker with children of 10. So minimum wage is $7.25 an hour, times 30 hours is $217.50. Uniform deduction would take wages below required minimum wage. So if that person were to file a claim, we would award them with $7.50. And yes, we've had this exact scenario. That's kind of why we have it here. Another question here. A worker is caught stealing $400 from the till. You fire the individual and report them to the police. Can you withhold their check to cover the loss? No, you must have written authorization from the employee to make deductions for a lawful purpose. And so it becomes a lawful purpose when you have that written permission. Again, if your policy says, and you can establish that the person did take the $400 from the till and you have the written authorization, you can make those deductions. You got about 5 more here. Reduction of wages must give notice of pay reduction prior to the work being performed in writing if requested. And record keeping must maintain any employment records for up to 3 years after termination, and it can be kept in any format, but as long as you keep it for at least 3 years. So at the time of hiring, you must provide pay rate, pay days in writing, specifically if they ask for it, just give it to them in writing. It makes it easier down the road. And so for wage and hour assistance, you have the Idaho Guide to Labor Law, required posters, frequently asked questions, and review employers' labor policies. We can do all those things for you. And that's our link down below, just labor.idaho.gov, and just search wage and hour and it'll pull you straight up. So disclaimer, the Wage and Hour Division is providing this presentation solely for educational and informational purposes. The information and related materials are presented as a service to give the public access to information on the Department of Labor's wage payment laws. The Idaho Code statutes are the official source of our wage payment laws. They can be found on the official website of Idaho legislature at legislature.idaho.gov. Statutes rules. Whew. Let's see. Questions? Nope, we've already got
Okay.
those. And so that's it. That's the last slide.
Okay. Well, thank you, Artie. And for those that are on the call, we will stay on and finish answering the questions that have been asked. But I do want to just finish up with a couple of things. Remind folks, our next one will be August 28th, the next webinar for unemployment insurance. Another good topic that I know lots of you may have questions on. So keep your eyes open for that. Again, it'll be August 28th. And we'll, like I said, we'll stay on and answer these questions as best we can. And if nothing else, it'll at least be on the recording if you have to go off. So for our weekly payroll period, can we put 40 regular hours on one check and overtime hours on another?
You can, because it's still documented. The person that's still been paid, you're just creating extra work for yourself.
Yeah. Okay. Can you require a salary employee to use PTO or personal time off for partial days off?
Yes. If it's in your policy, your established policy, and they sign off on it. So if I'm salary based and, if I take some time off, if it says something to the effect, you will use your vacation time to make sure you receive your full salary, totally legal. But the thing is, once those hours run out and that person misses, there's only certain times that you're going to be able to make deductions from the wages.
Also, just to let everybody know, in the chat is the website for U.S. Department of Labor, their wage and hour page. I also did a second one that focuses specifically on the overtime issues. So this one was going back to the example of the salary abuser. Works a few days on Monday and they are good for the week, is the question. I thought you could deduct full days of no work related things were done. And I think we answered that. So yes, you can do PTO. As far as actually reducing their wages, again, if they're scheduled to work 40 hours and they complete it in 4 days, and you're paying them salary, you wouldn't, I mean, they've still performed the work that was expected. So I don't know if there's, as far as what things are exempt, again, look at the federal DOL. That's who has jurisdiction over that. If the employee is on call for the weekend and we're required, let's see, are we required to pay them hourly even if they don't? Oh, we already did that one. If the employee is on call for the weekend, and are we required to pay them hourly even if they don't receive a phone call?
Yeah, I think we already got that one.
Yeah. If you have a salaried employee and they are let go or quit on the first of the month and you pay monthly, do you have to pay them for the full month?
No, you could, that final week, you can prorate it down.
Okay. The salaried employee, if a salary exempt employee is absent for 1 day, can you deduct 1 day of pay? They call in sick.
It depends on the absence. So if it's due to their own personal illness or injury, then no.
Okay. What is the difference between an exempt salary position and a non-exempt salary position?
Just the overtime. The exemption speak towards being paid overtime.
Okay.
Exempt from overtime.
If a hired employee comes in before their start date to fill out paperwork and also does benefits onboarding, should I pay for that?
Yes, it's probably going to be considered training or something of that nature.
So you would only have, I mean, and correct me if I'm wrong on this, Artie, but you wouldn't necessarily on the period of time that they were filling out the paperwork, but if they're meeting with HR, doing onboarding regarding benefits, that period of time
Yes.
should be paid. We don't pay people. Oh, okay. We don't pay people to smoke on the job. Does comp time need to be given at 1.5 hours or 1.5 hours?
No, because comp time is not made available to the private sector.
Just for clarity, we cannot make direct deposit mandatory.
Correct. It has to be voluntary. And it's suggested that if you're going to do it that way, explain to the employee you get paid faster. Just that's it, and you'll have your payroll faster. You can pay your bills faster. You can go do whatever you need because typically you're going to have your money probably a day earlier. But if that person doesn't want to be on direct deposit, then yeah, you have to go give them a live check.
Are the 48 hour business are the 48 hours business hours, or does it include weekends?
No, weekends and holidays are excluded.
When deducting from wages and meeting minimum wage, is it the net wage after all of the other deductions like insurance and 401k that cannot go below minimum wage?
So is it the net wage? It's the gross.
Gross
So
wages, yeah.
you'll make those deductions and then you'll get the gross amount that they're owed and then you do your taxes off that.
Okay. What if they get a payroll advance and their employment is terminated and they still owe us back from the advance? Do we still have to pay them minimum wage even though what they owe us is more than what their paycheck would normally cover?
If it's an advance, you can deduct dollar for dollar without needing written permission. So if they got an advance and they still have another check coming, and you have the documentation showing they received an advance, and that paycheck covers some of it, well, that's what you'll do. You'll just keep that paycheck and let them know this was because of the advance. And then if there's a remainder that they still owe, you can have them prosecuted, send them to collections, something of that nature. But at that point, I believe it becomes civil unless the dollar amount reaches a federal amount, like a felony amount.
If it is stated in policy and procedure that those will be deducted from wages if they do not last 90 days. So if there's something that says will be deducted from wages if they do not last 90 days, is the acknowledgement of policy and procedure sufficient?
Yeah, I probably have to read exactly what that one says because that one's kind of difficult. But yeah, if you got that written permission and they have the signed acknowledgement form, then you should be okay.
Again, the thing to be cautious of is just make sure it doesn't drop the person below minimum wage.
Yep.
If the uniform is provided by the company, can the deduction for the cost of the uniform, if not returned at termination, be authorized at the start of employment?
Yes, that's where you want to get it, is at the beginning of employment. When they're onboarded, have them give them a company policy, they sign the acknowledgement form so they're aware from the beginning that if you don't return the uniforms, it's going to be deducted from your wages.
There was a question is, where is the recording video posted? It will actually be sent out to all of the registered attenders, but it will also be posted on our, I think it goes actually out on our YouTube site, as well as you can access it through our website if you just do a search for webinars. Probably be the easiest thing rather than trying to give specific directions to it. So, let's see here. For clarification, salaried employees, when can you deduct their pay? If they are not working days, that are required, can you deduct that pay? So they're a salaried employee, but they're not working a day that they were scheduled to work.
No, unless it's one of the reasons, like if they're, I don't know, just want to take a personal day, have those personal days tied to your personal day. It's going to come from your PTO to pay for it to make sure you still receive the same. But it all depends on the reason why they missed.
Yeah. Okay. So there is again, regarding the exempt versus non-exempt, there was a statement here. I think they're looking for what makes an employee exempt from overtime. Again, that's a federal law. And the best advice or directive would be to go to the DOL wage and hour and look at those exemption versus non-exemption rules as it pertains to that.
And those are all on the fact sheet 17A and 17G, I believe.
Okay. If an employee refuses direct deposit and my payroll service charges for check delivery, can I charge that back to the employee?
My phone rang. So what was the question again? I'm sorry.
Oh, no. If an employee refuses direct deposit and my payroll service charges for check delivery, can I charge that back to the employee?
No. The employee wages are supposed to be given to them with free of charge.
Okay. Just a couple more. Under what circumstances can an employer deduct a full day of pay from a salary exempt employee? I mean, I think we already kind of would have to look at the federal laws on that one. Are we allowed to recoup background check fee if employee quits within 90 days?
Only if it's in your policy saying that if you quit before 90 days, this will be deducted from your wages, and you don't drop them below minimum wage.
And I think the last one, we have employees working with clients in the client homes. Do we need to pay staff for driving between clients, or can they clock out between each client?
If it's between clients, that's normal travel, normal days activities, so it's compensable time.
Okay, I think those are all of the questions that we have here. And
can I get that last question though? But we have seen employers have in their policies that drive time is paid at minimum wage. That's one way I think employers can use this to save on their budgets. Any drive time is only going to be paid at minimum wage, and when you're doing actual work, you're at your normal pay rate. Just to keep track of time. If there's issues about budgets and things of that nature, that's one thing you could do.
Okay. Well, for those that are still remaining, which still looks like a good bunch, again, thank you for your time. I would highly encourage, if you have specific scenarios still on the screen, are each of the labor compliance officers, as well as Artie's extension. I would encourage you to contact them based on which one is closest to you and ask your specific question. You can also contact your local office or any of our mobile sites, and they can at least direct you to the appropriate individual to answer those questions, whether it be directly related to wage and hour, or if you have questions related to unemployment insurance, other specific tax information, we can direct you to the appropriate individuals. Again, this recording will be sent out to those on. Oh, one more question. Can we pass on fees from the bank or payroll service for rejected direct deposit?
Ooh. Well, you can't charge an employee to receive their wages, but they rejected it. Gosh, never had that one. I would think, and this is just without consulting the other compliance officers, but in that scenario, I would think if it's in your policy and the employee signed off on it, given permission for that deduction in that situation, then yes, it would be okay if it didn't knock the wages below minimum wage. But we're having a staff meeting next week, and yeah, I'm bringing this one up.